In this panel, you have a group of very, very, very knowledgeable and very, very hardworking title affiliates. So please help me in this. Thank you. As we do normally with the panel discussions, we have questions that we submit so that we can each talk about something that is different and enlightening to you. But before we start, we're going to go down the line and we're going to have everyone introduce themselves and tell us briefly how long they've been in the business without aging themselves.
Good morning, everybody. Yolanda, Martinez-Arenas, WFG Title Company. I started October 6, 1982, so that pretty much puts me close to, I guess, 32 years in the business. I love it. We're so blessed and so lucky to be in this profession, so thank you so much for all your support. Thank you.
Good morning, Nancy Chan, Lawyer's Title. By a request of my old client down in the audience, my bio says 29. He says, no, Nancy, you're older than that. So, I'm making a correction. That's from our website a few years ago. So I've been in the business since 1981, so it's officially April, so it's 34 years now. I'm in the middle of the 34 years. Thank you for your friendship.
Good morning, Annie Fan, Chicago Title. I've been in the title business since 2005. Thank you.
Good morning, everyone. Joe Haggerty. I have been in the business since 2002. I left briefly for about a few years, 2007 to 2011, and have been back in it ever since. Thank you.
Hi, my name is Angie Tang. I'm with First American Title, and I've been in the real estate industry since I was 16. Hi, my name is Theresa Lamb with North American Title. North because they always get confused. First. Yes. Ours is directional. Hers is priority. Okay. Yes, I've been in this business for 10 years. Thank you.
And I am with Western Resources Title, and I've been in the business since 2005. I was a kindergarten teacher, and somebody told me you should be a title, and I thought, what a great way to call people names. And I love it. Thank you for your friendship. Let's get started. We're going to start with Theresa Lamb from North American Title. Theresa, can you tell us, this is something that people often get confused, what's the difference between a preliminary title report and a property profile?
Okay, a property profile is brought to you by the vendors, third parties, which gives you reports such as transaction histories, plat maps, description of property, legal descriptions, and all that. I'm sure you already know that. And there's no consequence if there's any misinformation. But the preliminary is a prelude to a title insurance policy. And it shows, it's actually researched by the title company itself to see if there's any encumbrances or any clouds to the title or exclusion to it that we cover or don't cover, and that you need to clear it out before the close of the escrow. And so this that's the difference between the two. Perfect.
Over to Nancy. Nancy, what is a sub-escrow fee? Is it a junk fee?
It's a very good question. Some of you that's been here a long time should know this. I think prior to 1980, it was the early 80s, all the funds, all your money in and out from buyer, wiring, paying off all the termite, all the vendors, everything. The lender funds to the escrow company. So title company never touch any money. We just issue policies. And escrow did all the paperwork and also disperse all money and pay all money. You even wire out to pay your escrow, pay the lender for their old payoffs. But there were a few escrow company that had trouble with their trust account. So all the lenders got together and said, no, we want the title company to be in charge of our money. We want to fund to the title company, not the escrow. Escrow had a lot of things to do. They had a lot of power then. But title company did not volunteer to do all the dispersing, all the payoff. Okay, so since that was put onto the title company to do that, and we don't have the manpower at the department to do all the disbursement, confirming the payoff amount. We even have to call and get last minute updates on the payoff from the lenders for the seller. The insurance commissioner, they decided, yes, you can do it, but you need to charge for it, because you're not doing title policy work. You're doing escrows work. So that's why it's called a sub-escrow. We do all the disbursement, we verify all the wiring, we verify all the payoff. So the escrow now is left to pay the termite and all that stuff, but as far as the lender's part, title company took over. So we have to charge that. It's not a junk fee, it's actually work that we're doing on behalf of the buyer and the seller. The new buyer wires in the money, we take it, we verify the balance to be paid to the old lender, and we have to do all that. So that is not a junk fee, okay?
Thank you very much. All right, over to Joe. Now we're going to be talking about stuff that shows up on the prelim that you know is the crux of what we do. Joe, my client has an open loan showing on title that they understand to be paid off. What is required or what can be done to remedy this situation?
Okay, so this is a very common issue. It happens most often when it's a private beneficiary from maybe like 20 years ago, and probably many of you have seen this issue. It can often put a deal at a standstill, but there's many options to review. First off is statute of limitations, which I believe in California is about 60 years. That's a long time, so that's not really going to be the case to resolve the issue. Next to that could be an expiration date on the promissory note, so that would be something to review, but that's not always something that can be found easily if it's an old note. Aside from that, you should be asking your client what they have in their records. Often they don't know what it is that they're looking at when they get something from a lender. They might have a paid in full letter. They might have also been sent the deed of reconveyance that just needs to be recorded, and they've been asked to record it and they've been holding on to it. So that's something you should ask your client. Another thing that a title company can do is we always look for the last point of insurance when we do a preliminary title report, and that's how we display what's going to be on the prelim. So if there was insurance between the time of that deed of trust and the current, and we are able to pull a copy of that policy and it does not reflect the deed of trust, that's a way to excuse it. We would also ask for indemnity from the last title insurance company or review the closing statement from the last time they closed. Aside from that, if it's a line of credit, you might review the credit report. If it shows that it's paid off, you might just need to have the line of credit closed before they would issue a reconveyance. The last resort, aside from that, all those other possibilities is basically to pay for what's called a bond for a lost note. If you ultimately just can't find the beneficiary or anyone involved in it to release the lien, and that's something that is going to be a fee for the owner. They're going to have to pay a percentage based on their credit score, and also depending on what the title company wants, the percentage of the title company wants to be covered, because it's insurance for the title company who's now going to be insuring it so that they can feel safe from risk.
Right, and just I'll interject here, something that is often a misconception with title. They believe that title companies clear things off of a person's title. It's not that. We report what needs to be handled, settled, paid, understood by the both parties before we're able to insure. So it's never an issue of the title company not being able to clear. It's the title company not getting what they need from the clients in order to clear and be able to insure. Moving on to Angie. My client has filed bankruptcy in 2011, and they were able to remove the second deed of trust. Will you accept this? What steps are needed?
Okay, it's a pretty complex issue because bankruptcies, there's different types of bankruptcies, as we all know. There's Chapter 7 and Chapter 13, which are the two most common ones. Chapter 7 will only remove the credit cards and judgments, so that is usually not going to work. Usually for Chapter 13 now, that might work, but it's a 3-year repayment program that usually you have to request for with the creditors. And deeds of trust are secured against the property, so it makes it really, really tough to get those removed. However, sometimes there are exceptions with the court. If there is, we would need a certified copy of the abstract of judgment, the abstract of judgment, to take a look at, and take a look at the BK paperwork, because we never know what is actually going to be resolved in court. What else? Yeah, that's pretty much the main thing. It's case by case, of course, because it depends on what the BK has been approved on. Anybody have any questions?
And you probably had this is something that I'll add to it. You probably had this, Angie, where you're going to close and the client brings you a debt that is shown as discharged from the bankruptcy, but yet a lien has been filed against the property.
Yeah.
You cannot use that bankruptcy discharge, the title company cannot use that bankruptcy discharge information. What do they need? They need
to avoid lien.
They need a what is it called, an order.
Yeah, in order to avoid lien. So if
It's a court order.
Yeah, it's a court order, and we need to see the certified copy usually.
Perfect.
Yeah.
Yeah, so it can be kind of tricky with bankruptcy. Now, over to Annie. Annie with the Chicago Title. My client has a child support judgment that recorded several years. Is it still open since the child is now an adult? That's a good question.
So first, child support lien doesn't fall off the regular normal 10 years. They need a full release of the lien as though the child is an adult right now. So typically, escrow will draw demand, and they're gonna call the district attorney office to request a document. It's called a notice of mature installments. They're gonna look into that document to make sure it has been, the judgment debtor has been paid and it's current in this judgment. So typically, the child support lien doesn't really fall off just because the child, is over, it's an adult. So.
Perfect. Now, all this talk about liens and stuff that shows up on a prelim has prompted me to ask Yolanda, what is the importance of submitting, why is it so important to submit the SI in a timely fashion? Tell us some horror stories.
Oh, do I have horror stories? Okay, SI is Statement of Information or Statement of Identification, or sometimes you might hear it as a GI, which is General Index. All of them pretty much mean the same. It's a form that the title company provides to your client, and they fill it out who's on title, the seller or someone who is refinancing. Now, people are very sensitive and emotional with this form. They feel it's an invasion of their privacy. I sometimes think, and I've heard, that they believe that we're going to sell it, their information, and they're going to start getting calls, or if they do have an IRS lien, that now for sure the IRS is going to come down on them, and that's not it. This is private information. We do not sell it or release it. It is solely for the title company's purpose to actually do our research. Now, the thing that people have to understand, and even as a realtor, when I was a realtor, I had clients that didn't want to fill it out because they were hiding information. So it's like, okay, fill it out in private if you don't want your spouse to know. I had one where the husband didn't tell his wife that he was married with kids before, so he literally had to pull me aside when I was taking to fill it out separately. That's fine, I don't care, just give me the information correctly and fill it out in its entirety. It's really, honestly, to the benefit of your client to fill it out, because a lot of times it's to prove that that lien isn't theirs a lot of times. Because right now, what we just went through in these rough years, there were so many liens and judgments, more than ever. In these last, from 2007 on, there's been more judgments and liens and everything than ever. So if your client has a common name, and they might be innocent and free and clear, and they may be on the up and up, but it's actually to their advantage for them to fill that form out correctly, properly, to prove that these liens are not theirs. And here's the problem. Even though we live in a day and era of modern technology, it's still humans, it's still people that have to visually look at these pages and go through them one by one. And that's what people forget to understand. For an example, just say the seller's name is William Smith. A title company has to search William Smith, Billy Smith, Bill Smith, we have to search every name, every variation close to that name. So you have to be kind to the title companies because there's such names so common that we get literally pages and pages of liens with the same name or very similar, and each page can have 25 liens. Not all of them would have social securities, unfortunately. So again, it takes a live person to go down the line. Now, sometimes title companies don't know the customer up front like you do. So that's why it's important to put as much information as possible. And do it in a timely manner because this has happened many times. And I know everyone is busy. But it's so important that in the beginning, even when you take your listing, have that SI filled out up front. Don't wait till you open up escrow. And please don't wait till the end of the close of escrow. Because I know this has happened to all of you guys, and I know you guys, but sometimes we get the SI the night before recording. When it's being set up to record, to close, and that's when we get the SI. And if it's a common name, or if it's before a holiday weekend, or if it's the end of the month, oh my gosh. And we want to close the transaction. We're not in the business to kill the deal, because you know what? We don't get paid. If you don't get paid, we don't get paid. So we want to close it. But help us help you. Give us that SI up front. Give it to us in a timely manner. Let us help and work with you to clear all those liens. And we do understand. I've had situations, and maybe I'm sure all of you, I've had a couple of files. I had one file, there was an FBI agent, didn't want to give information. I've had some sheriffs who were selling, didn't want to give information. I understand, we understand. You know what, if they don't have a common name, we can really, try to accommodate them and work around them if they don't have a common name. But if they have a common name, it's a case by case, and please understand, it's actually to your benefit to prove maybe that a lot of these liens aren't shared, so we can expedite your transaction and close it. And if it is your client's lien, then let us give you as much notice as possible so that you can work on releasing these liens.
Right. Good points. And it's important to remember that the point about the names, the common last names. Hispanic names too, Asian last names that are common, your Lees, your Gonzalez's and stuff.
Martinez.
They can stack up.
Uncommon names are also, we also need the SI. I had one where we plugged in the uncommon name at the beginning when we ordered the prelim. Later he gave us the SI. When we submitted it, when we run the SI again, or the GI again, plugged in his last four of his social, it brought up another lien that didn't come up with his name alone. So uncommon or common name, we still need it.
We need that information. That's criteria. That's very important. Okay, over to let's go over to Annie again. My client deeded his property to a family member. So why is my client's judgment still showing attaching affecting the property?
Well, you must pay or have the judgment creditor to run a partial satisfaction to release the property. You cannot just deed off the property and escape the creditor. That's a reason, like what we all were saying, you needed to provide the SI. The title company will run the names and last four digits of social to make sure that this thing doesn't happen. Thank you.
Perfect. Nancy, how long does title insurance last?
You timed this perfect, because it ties into what Annie's question was. Title policy, who do we insure? We insure the buyer, right? So, when we insure the buyer, do we insure the property or the buyer's interest and possession right to that property? That's the difference. So when Nancy Chan buys the property, I'm insured. But what if I quit claim to my brother? The policy is void. We see this every day. And I tell my client, do not do quick claims, think about it. And I have agents say, I'm just going to put the daughter's name out. The father is not in this country, in China. And then she can quit claim to the father when he comes. Then why do you bother to buy a title policy? Well, you need it to close escrow, but you don't have a policy. So policy only follows that insured. The person that owns a policy, they have the right, possession, interest, estate to that piece of property. Now I think everybody's going, oh. And that is why when somebody quit claims, that person, if they have a lien, it's still affecting that property. All right? So title policy lasts for as long as you own the property. I bought my house in 1997, haven't changed title, so I'm still good. My policy will last forever. And I want to add something to it. A lot of people now ask title company for discounts. And everybody knows Nancy is really tough. I don't give a discount. So my reputation is that I'm expensive. I'm not expensive. I just do not give discounts. The reason why we're all governed by the Department of Insurance, we're not allowed to give any rate that's not on the book. And the book is regulated by the Department of Insurance. So when you have a policy that will last forever, 1997 now, I haven't paid a dime for renewal. And I paid almost $1,500 for my car every year. And the $1 million property, the title policy is $2,900, something around there, 25 to 2,000, I'm not exactly sure. And you don't ever have to pay a renewal the rest of your life, and you're insured. Try that, compare that to any kind of insurance. So it's the cheapest insurance there is on the face of this earth. So please leave all our colleagues alone. Please do not ask discounts. Because we talk to each other, we're going, you know, so-and-so is going to give me a discount. So-and-so says that they would, you know, if you compare it to your insurance on your car is not $1 million. And your car insurance is probably $2,000, $3,000, you know, and then every month, every year, every quarter, however you pay, you don't pay, you lose it.
And you know, none of us in title should really be judged by what the insurance rate are. We have to be judged by what we bring to the table.
Well, you know what it is? I think we're normal. We only want to help our client, right? You want to help your sellers, you want to help your buyers, so sometimes you overprotective of them. So this is, sorry, you gave me the mic, so I'm going to...
Angie, did you have something that you wanted to add to that?
Also, if you're going to change it in, I know a lot of people are moving it from individuals or joint tenancies into a trust. The trust is still going to be insured under that same policy.
Right.
And if it was before, I think it was 89, well, you can ask for an endorsement. I'm not sure if it's probably the same with, that you can ask for an endorsement if it was prior to 89, I think it was 89, that you can
Change of name.
change it into the trust with
Trust,
it still
exactly.
being insured.
Okay, clarification on that. A lot of people buy an individual and change it to a trust or change it to LLC. You can, the way you do it is that it has to be the same parties, because we're talking about policies, and yet we're talking about also the assessors for reappraising your property tax. So it's not the same party. Nancy Chan transferred to my brother's trust. That doesn't work. You're going to get reassessed.
Yeah.
Okay? So same parties for the endorsement. Thank you.
So Joe, tell us now, what happens when, in addition to the policy being void now because it's changing, but what are the issues that arise when people have made several transfers to the title without purchasing title insurance?
And that question is a little different because this is not necessarily whether they transferred to a different party or they're transferred to themselves. When there's a, I'm sorry, if they do transfer to themselves, that doesn't make any sense. But okay, when a lot of times we come across a new transaction and there's been a quit claim or some sort of transfer of title in the past, and that's really the issue is when we come to drawing up a new preliminary report, what are we looking for? We're looking for liens and judgments against the person's name aside from the property. A lot of people think they can avoid paying things by just transferring it into someone else's name. That's not how it works. If you transfer it to someone else's name and there was a lien or judgment, we're going to be looking at anyone who's been on title since the last point it was insured. Right. And we're going to be checking for liens and judgments. We're going to be asking for a statement of information, affidavit for an uninsured deed that that person did in fact sign off, because we're insuring the property against fraud. We're insuring the property against the validity of everything that's happened since the last point of insurance. Other things that we're going to ask for, if they've deeded it to an LLC or a corporation or out of a corporation, we're going to ask for corporate resolutions, corporate entity documents, all that stuff to make sure that it was all properly done. So you cannot get away with just moving title between people without title insurance. And so that's, you know.
Right. One thing that I should, we're going to take questions at the end, Carl, at the end of our discussion. One thing that I want to add to this whole topic about quick claims and grant deeds, you know, in the past, title companies have done what are known as accommodations, which is where people want to change something on title. People want to change something on title, and they want to change it, put it in their son's name or their daughter's name, or quick claim it to somebody else. There are document services that you should consult, or you should have your clients consult to do that, and not get your title companies involved or your escrow companies involved. I know of some agents that were drafting grant deeds for their clients when they wanted to make changes after they purchased something, and they totally got hit on, you know, they had a major lawsuit, and you know, and the title company is going to protect themselves. They're not going to be, you know, they're not going to record anything that's not part of their transactions. So keep in mind, people will ask you, and they'll hound the agents. They'll say, "Well, I just wanted, you know, I'm afraid that my parents are getting so old, and you know, we want to make sure that we save the property so that it doesn't go to the government." You know what? You have them speak to a proper professional to guide them on how to put a trust, instead of getting your title company or escrow company involved and doing a quick claim that later, with the swipe of the pen, is going to cause major problems. Do we all agree?
Absolutely.
Do we all agree on that? That's something that's just a takeaway that you need to know. Moving right along. What happens, Angie? My client has a POA that was signed in 2011. Will you accept this? It is not a durable power of attorney.
There are 5 different types of power of attorneys. Most power of attorneys, the most general ones, the more common one is the general and then the durable. With power of attorneys, we usually require them to be signed within a year, only because they can be canceled or revoked any time. So that's why we ask them for a year's time frame usually. However, there have been instances where we have been able to allow it if it's past a year, of course with explanation and maybe a written letter to make sure that we're going to be ensuring, you know, having the right documentation for our files. Now with power of attorneys, now if a person dies, obviously the power of attorney, any of the 5 will be void. With durable power of attorneys, that's when if the person is incapacitated and they're unable to sign or unable to think on their own, and that's when a durable would come into effect. Now for specifics, that's for specific properties usually. So there are 5 different ones, and the most common ones are the durable and the general and the specific.
Perfect. And usually power of attorneys, we need to reiterate,
Yeah.
power of attorneys are usually used in someone's absence or incapacity, but when it comes to real estate, it's usually for absence more so than it is for incapacity.
Yeah.
Can I add something to that? The fundamental value of getting a power attorney in the law was for somebody that is going to be temporarily absent, not long-term absence. So with long-term absence, you go to the attorney, get the durable power attorney. But power attorney is temporarily, short absence. And with technology nowadays, overnight mail, you can do that in any country. So there's really no excuse of not getting a new one. But like Angie says, we look at everyone case by case. Thanks.
And let's see, moving on, Yolanda, what happens when the vested owner is deceased?
Okay, this is, I've had a couple of fun transactions of lately of this situation. One transaction I had was the man, with his common law wife or girlfriend, with a child. He signed a quitclaim deed while he was in the hospital, and then he died a few hours later. And then she recorded it during the time of the planning of the funeral. She recorded it. So obviously this was kind of reversed because so they say that he signed it before he died, a few hours before he died in the hospital. The problem with this in this situation, because it's his first borderline, is that he was not competent, obviously. We gave the chance to the family to say, okay, if we get a doctor's note that he was competent, then we'll honor it. But no doctor in that hospital would give. He was on morphine. He was on his last hours, and so we could not honor that. Okay, but what happens now? A lot of times it's important if you're working on a listing and you yourself as a listing agent knows when someone is deceased before even the title company knows. So when you're taking that listing and someone's on title, Jane Smith, and she's deceased, but she's still on title, and it was not vested in a living trust, it was not vested as her and someone else's joint tenants, then now we have a problem because she's deceased and now the property has to be probated, okay? And that's what's so important. So if there is documentation, if there is a deed that was signed, notarized, if there was trust, paperwork, will, the more the better. The title company will look at it, and it's a case by case. There's times that we can avoid if there's enough information. I just had the transaction. Everything was in line. They just didn't know they had to record it, but everything was signed, notarized, trust, and everything. They had everything. They just didn't. Okay, so it's a case by case. But in a situation, if it is in the individual's name and there's no trust and there's no joint tenancy, then you have to do probate. Or if there's an unrecorded deed and it has a story behind it, then the title company will ask that you get a court order confirming that deed that was not recorded, okay? The situation thing is that the title companies were not the judge, were not the courts.
Right.
And I think that's the problem, that people think that, oh, well, you're the title company, you can put that stamp on it. No, we're not the judge and we're not the court. And what we're trying to do is do our job, ensure the transaction, protect the new owner, and we don't want, after if we turn away and do sloppy title work, turn away and look away, and after we close, and then an heir comes, knocks on the door and says, I didn't know that the such and such sold that property, I have an interest in it, I want the property. Guess what?
Right.
We're all going back to court.
What she's saying is we have to be paid legal paranoids. Because we do. We have to be paid legal paranoids. We're paranoids for you because a court lawsuit can bring everybody down.
Exactly.
Moving over to the last question that we have. What are the key points, Theresa? What are the key points to know about supplemental taxes?
Okay, I brought this question up because I have a couple of customers calling me and said, why are my clients getting another tax, supplemental tax? What is it for? Well, this supplemental tax was signed into law by the government, by the governor in 1983, and it was to raise revenue for schools. And what it does is it requires the county assessors to reappraise the property whenever there is a change of ownership or when someone is undertaking a construction of the property. Now, there are exceptions to the rule, but that's not what I'm going to talk about today. And anyway, what it is that how it is done is that the assessors will then look at the prior assessed value to see the difference between the new assessed value and the old one, and they will prorate it throughout the to the remaining months of the year, and the fiscal year ends in June 30th, and that amount will then be called the supplemental property tax and will be mailed to the new owner. And so that's what
And it's within the first year.
Yes.
And the proration is really kind of confusing. So you just, if you're assisting a buyer, you need to let them know that they will have supplemental taxes.
Yes, that's
And
very
they can
important.
expect it, and if there are on the county web pages, there are tax assessor, there are estimators for that, so that you can figure it out. But it's good to remind people, like Theresa is doing, that if you have buyers, let them know that they can expect this whirligig sort of tax that shows up at the end. That's about all the time that we have for the panel discussion.